Here is something that should be impossible in a constitutional democracy. In 2015, Nigeria's Supreme Court, sitting as a full panel of 7 justices, issued a ruling that said, in plain English, a legislator who defects to another political party automatically loses their seat unless the division in their original party is so severe that it makes it impossible or impracticable for that party to function. Division must be at the national level. Anything less does not qualify. That ruling has never been overturned. It has never been challenged by a higher authority. It stands as binding precedent on every court in Nigeria. 10 years later, in February 2025, a 5-justice panel of the same Supreme Court dealing with the Rivers State crisis issued a ruling that effectively contradicted it. The 5-justice panel did not cite the earlier ruling, did not acknowledge it, did not explain the departure. It simply announced a new principle on the judicial equivalent of the fly, that only the legislature itself can declare a lawmaker seat vacant for defection. Not the governor, not the courts. A 5-justice panel cannot overrule a 7-justice panel. That is not a debatable legal point. That is hierarchical procedure. And yet, the February 2025 ruling is the one that has been used to restore the 27 defecting Rivers State House of Assembly members to their seats, freeze Rivers State's federal allocations, and reshape the entire political architecture that controls who governs Rivers State in 2027. Understanding why and what the 2015 ruling actually says is understanding how Rivers State politics actually works, and that is what this video is about. Before we go further, if you're new here, Naija Brief exists for one reason: to give Nigerians the political analysis that mainstream media won't. Whether you're in Abuja, Lagos, Kano, Port Harcourt, or London, this channel is for you. Hit subscribe and stay with me. This gets deeper. The case is called Abegunde versus the Ondo State House of Assembly. It was decided by the Supreme Court of Nigeria in 2015 with a full 7-justice panel. The facts were simple. Ifedayo Abegunde was a member of the House of Representatives, elected on the platform of the Labour Party. He defected to the Action Congress of Nigeria. To justify his defection and retain his seat, he argued that the Labour Party in Ondo State was factionalized, internally divided, and therefore his defection was constitutionally protected under Section 68 1G's proviso. The Supreme Court rejected that argument with precision. The court ruled that division justifying defection must affect the party at the national level. A division limited to one state does not qualify. The court went further. Only such factionalization, fragmentation, splintering, or division that makes it impossible or impracticable for a political party to function as such will justify a person's defection and the retention of their seat. And critically, the court confirmed, if that standard is not met, the defector automatically loses their seat by operation of law. The moment they defect without justification, the seat is gone. That is the law. That is what it says, and that is the standard that 27 Rivers State House of Assembly members failed to meet in December 2023.
Now, let us look at what happened in February 2025, because it is one of the most constitutionally controversial Supreme Court actions in recent Nigerian history. In December 2023, 27 members of the Rivers State House of Assembly, loyal to Nyesom Wike and hostile to Governor Fubara, ostentatiously announced their defection from the PDP to the APC on the floor of the House. Under the Abegunde standard, their seats were immediately vacant by operation of law. PDP at the national level was not in a state of collapse. It was not impossible or impracticable for PDP to function nationally. The defection was not justified. Their seats were gone. The 4 remaining PDP-loyal members, Fubara's Rump Assembly, began sitting as the Rivers State House of Assembly. The governor presented the 2024 appropriation bill to them. They passed it into law. This was the only constitutionally defensible course of action. You cannot present a budget to legislators who no longer legally hold their seats. What followed was a legal siege. The 27 defectors filed suit. Courts ruled in conflicting directions. The Court of Appeal upheld the Federal High Court's position that the budget passed by the four-member assembly was invalid, that it lacked quorum. This reasoning assumed that the 27 defectors were still valid assembly members. That assumption directly contradicts the Abegunde standard. Then came February 28, 2025. The Supreme Court, in a judgment delivered by Justice Emmanuel Akomaye Agim on a 5-justice panel, ruled that 1. The 27 defected lawmakers were to be restored and recognized as valid members of the Rivers State House of Assembly pending final determination of their status. 2. Governor Fubara was ordered to represent the 2025 budget to the Ameule-led Assembly. 3. Payment of federal allocations to the Rivers State government was stopped. And 4, and this is the most constitutionally explosive element, the court announced that in cases of disputed defection, only the legislature itself can declare a seat vacant, not the governor, not the courts. That fourth ruling is where the Supreme Court directly contradicted itself. The 2015 Abegunde standard had confirmed that the consequence of unjustified defection is automatic. It happens by operation of law. You do not need a court order for a seat to become vacant when the constitutional conditions for vacation are met. The seat is simply gone. The 2025 panel reversed that without citing Abegunde, without acknowledging it, without convening the full court that is required to overrule a 7-justice precedent. ALDRAP, the Association of Legislative Drafting and Advocacy Practitioners, filed a formal application to the Chief Justice of Nigeria in March 2025, asking for a review of the February 28th judgment by a full panel of 7 justices as required by Order 8, Rule 16 of the Supreme Court Rules 2024. They argued correctly that a 5-person panel cannot overrule a 7-person panel. Their application has not yet been publicly resolved. Now, if what I just told you surprises you, drop a comment below. I want to know your reaction before we get to the part that changes everything. Here is why this constitutional collision matters directly for what happens in Rivers State in 2027. The February 2025 Supreme Court ruling is the legal foundation on which the APC's Rivers State political structure is built. The 27 lawmakers were restored to their seats on the basis of that ruling. The Ameule-led Assembly, recognized on the basis of that ruling, was the legislature that became the backdrop for the APC's party operations in Rivers State. The 6-month state of emergency declared in March 2025, suspending Fubara, was politically enabled by the instability the ruling created. The APC's choice of Kingsley Chinda as governorship candidate and Chinda's entire path through the APC primary runs through the political reality that the 2025 ruling created. If the 2015 Abegunde standard is the controlling law, then the 27 lawmakers lost their seats in December 2023. The APC's political machinery in Rivers State, built substantially through and around those lawmakers, was assembled on a constitutionally infirm foundation.
This is not a theoretical argument. ALDAP has an active lawsuit before the Federal High Court in Abuja making exactly this case. They are asking the court to declare that Chinda's defection was unconstitutional under Section 68, subsection 1, subsection G, that his House seat was automatically vacated and that he is therefore ineligible to contest the 2027 governorship. The case cites the February 2025 Supreme Court ruling's procedural requirements for valid defection announcement, requirements Chinda arguably failed to meet when he contested the APC primary before his formal floor announcement. The two rulings, 2015 and 2025, are now in direct constitutional tension, and every legal challenge involving Rivers State's political careers in 2027 will eventually force a court to choose between them. The damage done by the 2015 versus 2025 Supreme Court contradiction goes well beyond Rivers State. The Supreme Court of Nigeria is the apex of the country's judicial architecture. Its authority rests on the coherence and predictability of its rulings. When a smaller panel of the same court contradicts a larger panel's settled precedent without citing it, without overruling it through the proper procedure, and without convening the required full panel, two things happen simultaneously. First, it creates a legal vacuum. No judge in a lower court knows which Supreme Court to follow. Second, it signals to political actors that the judiciary can be navigated, that with the right case, the right panel, and the right timing, even binding constitutional precedent can be effectively circumvented without the procedural burden of actually overruling it. Constitutional scholar and human rights lawyer Chidiondim Kalu described the February 2025 ruling with precision. The court had announced revolutionary jurisprudence on the judicial fly. And when the Chief Justice of Nigeria was reported to have attended a sword-turning ceremony with Nyesom Wike shortly before the ruling, the institutional optics made an already controversial judgment more difficult to defend. The Civil Society Legislative Advocacy Center, CISLAC, was blunt. The Supreme Court's handling of the Rivers State defection question undermines the very constitutional principles that ought to guide political conduct. That is not a fringe view. It represents the consensus of Nigeria's constitutional law community. For diaspora Nigerians and for international observers of Nigerian democracy, this matters for a reason that transcends Rivers State. Nigeria's democratic architecture functions on the premise that the Supreme Court is a reliable constitutional referee. When the referee contradicts itself in a politically charged case with a smaller panel without proper procedure, the entire system of constitutional predictability weakens. Every opposition politician, every civil society organization, and every investor calculating Nigeria's governance risk needs to account for what the 2025 ruling revealed about the reliability of Nigeria's constitutional enforcement infrastructure.
3 things to watch before May 2027. First, ALDRP's review application to the Chief Justice of Nigeria. The request for a 7-justice full panel review of the February 28, 2025 ruling is pending. If granted, it is the most consequential legal event in Nigerian constitutional law in a decade. A proper 7-justice review would be forced to confront the Abegunde contradiction directly. If the full panel restores the 2015 standard, every defection-based political position in Rivers State and potentially nationwide faces legal challenge. If the full panel upholds the 2025 ruling, the anti-defection provisions of Section 68(1)(g) and 109(1)(g) effectively become unenforceable, because only the legislature, which is itself controlled by the ruling party, can enforce them. Second, the Federal High Court ruling on ALDRP's Chinda disqualification suit. This lower court case explicitly invokes both the 2015 Abegunde standard and the February 2025 procedural requirements. It asks the court to navigate the same contradiction. Watch for the Federal High Court's handling of the 2 precedents. Whichever way it rules, the case will go to the Court of Appeal and almost certainly to the Supreme Court, arriving there in the months closest to the 2027 election. Third, the political signal from the Chief Justice of Nigeria's conduct. The institutional independence of the Supreme Court is itself a political variable in the Rivers State crisis. How the Chief Justice responds to the ALDRP review application and whether the full court is convened will tell Nigerians more about the condition of their judiciary than any public statement from any political office holder. What ordinary Nigerians must understand through all of this complexity is one principle. Constitutional provisions are only as strong as the institutions that enforce them. Section 68(1)(g) says what it says. The 2015 Supreme Court told you what it means. The politicians who defected in violation of it, the courts that restored them, and the political structures built on those restorations are all operating in the space between what the Constitution says and what the institutions have been willing to enforce. That space is where Rivers State politics lives. It is also where Nigeria's broader democratic health is being decided.
and the 2015 ruling, however much it has been obscured by subsequent judicial maneuvering, remains the blueprint that any serious constitutional argument must eventually return to. If this analysis gave you clarity, share it with one person who needs to understand what is really happening in Nigeria. Like, subscribe, and I will see you in the next one.